Welcome to Employee Benefit Plans and Business Sense.
Hey everyone, welcome back to an all-new episode of Employee Benefit Plans and Business Sense with Lank and Kathleen Salas over at KLB Benefits Law Group. I am your host, Mike Leon. You know, Don and Kathleen, they've been helping employers and benefit plan service providers navigate the complex legal requirements of employee benefit plans. And they've got decades of experience in employee benefits law, guiding clients through compliance matters, corrections, even IRS and DOL audits. Today's episode, we're going to be talking about retirement plans and especially retirement plan terminations. Kathleen and Don are going to go over what it means to terminate a plan, why employers choose to do so, and what the process actually involves. Ladies, it's good to see you as always. Kathleen, let me start with you on this. What the heck is a retirement plan when it's terminated? I think I know what it is, but what does it mean when it's terminated?
Well, it's good to be here, Mike. What it means is that basically the plan is frozen until the assets are terminated. So no new participants become eligible to participate, no new contributions are earned, and the process from the point of legal plan termination is just they can take up to a year to then get the assets out of that plan and either into IRAs or other employer plans or, the employee's pocket, whatever, they choose. And so that's what it means, for a plan to be terminated is just sort of like it stops. And then over time afterwards, it kind of just goes away.
And I guess a natural follow-up is, why would a plan sponsor decide to terminate the plan?
Well, sometimes they're having, financial difficulty and they just can't maintain a plan anymore. And so they decide to terminate it. Frequently, plans are terminated when there is a merger acquisition situation where the new owner is not going to want to take on that plan. So they terminate before the close of the sale, and that way the new owner doesn't have to sort of take on the plan for whatever reason. Sometimes it's just the policy of the buyer that they just do that. Other times they see something they don't like or they already have their own plan. And then the other situation that I see plan terminations in is sometimes an employer, the employees just are not interested, they're not participating, and so it's not worth the administrative expense of having the plan. And so an employer decides to just, be done with it.
Mm. Well, in that fashion then, and along those lines, what needs to happen in order to make sure that the plan, the retirement plan is properly terminated?
Well, I think, the bare bones is that the employer needs to adopt resolutions, terminating the plan as of a specific date. And then that's usually enough to basically just put it in, say it's legally terminated at that point. But from there, there's more to it. They have to bring their plan up to date with any current law that, even if the deadline for adopting those amendments hasn't happened yet, when you terminate a plan, it kind of accelerates it. You bring it up to date. Then what has to happen is that they usually the TPA, the third party administrator, but somebody has to send out notices to all of the employees, letting them know that the plan's been terminated. Um, and a lot of times that notice has to go out, uh, 30 days or so in advance. In a merger and acquisition situation, that time, you can notify employees after, but then you need to let them know you've got X number of days to complete distribution instructions. And then, if you don't complete a direction to put it in your IRA or your new employer plan, then it's going to be automatically rolled over into an IRA with this company. So that notice needs to go out, and then distributions need to be processed. And then, once all of the assets are out of the plan, a final Form 5500 needs to be filed. And that's how the IRS and the DOL know that that plan is gone.
Right, right. Yeah, I want to go back to something you said a second ago about maybe they can't afford the plan anymore. There's a merger or an acquisition that happens. Are there any other common business situations that typically leads to a plan termination, or are those pretty much it?
I mean, I would say those are the big three. It's like a company goes into bankruptcy or just is having a hard time, so they're shutting down the whole company and the plan goes with it. I would say the majority of time that I see plan terminations are in an M&A situation. And occasionally, we work with a lot of smaller employers who, they don't get that much interest by their employees in participating in the plan, and so they decide to shut it down. I sometimes now this is sometimes plan sponsor wants to terminate the plan because it's really messed up, and they think that by terminating the plan, they're going to somehow cut off any chance of getting caught or having to fix it, which that's another thing I would add to that list of things that need to happen when you terminate a plan is it should be looked at to make sure that there are no failures that could jeopardize tax qualification. So that's part of that should be part of that process, is looking at the plan's health and then fixing whatever needs to be fixed. So I would say the sort of the unusual and kind of futile reason that some employers want to terminate is just sort of like, we've messed this up so bad, let's just terminate it and not have to deal with it.
Dog, is there anything you wanted to add?
I was going to say, I think that some employers feel rather traumatized by surprises and shocks of plan compliance problems identified, and they might be reeling from the expense of having to correct something by making contributions to the plan, or it might be an employee relations fiasco as well to have plan corrections be required. But generally, you have to fix those anyway. So once you're over that hump, why not keep the plan going? But still, I think that some employers have an emotional response to it and just want to be done with it.
So, Kathleen, can you explain? So the plan's terminated now. What happens to the participant accounts?
So the participant accounts continue to be held with the custodian, and they can still direct investments until such time as they get a distribution or a rollover. So what happens to those assets is this is one of those situations where normally, participants with a certain amount of money in the plan can leave their assets in the plan even if they're no longer an employee. But in this situation where a plan's terminating, their assets can be forced out. So usually what happens is they'll be given like 60 days or something to get in their election to where they want the money to go. But eventually it all gets just, pushed out of the plan and then goes into those various places that the participant can elect. I should also note that when a plan is terminated, even if they have a vesting, which is that sort of, the longer you work, the more right you have to the employer contributions. That's what vesting is. When you terminate a plan, all participant accounts have to be 100% vested. So even if they maybe haven't earned that much vesting because they haven't been with the company that long, if you terminate the plan, all of a sudden it goes from 20% vesting to 100% vesting. So that's something employers need to keep in mind too, because all of a sudden, all that money that they've put in the plan but are holding, some of it's being kind of held back and, to encourage people to work longer. All of a sudden, that's 100% vested and that's going to be distributed as well. So, and it's still protected. All the same ERISA protections apply during this sort of post-termination period. And eventually they go to wherever the employee wants their money to go.
Mm. And what records need to be kept once the plan is terminated? Is there like a length of time that they need to be kept for?
Yeah, I mean, record keeping is always a judgment call, but generally 7 years after the plan is terminated. That's sort of the general ERISA requirement, where any documents that support a Form 5500 filing need to be kept for 6 or 7 years. And then there's the issue of keeping records in order to defend against a lawsuit. But most statute of limitations have run after 7 years, so that's sort of a good rule of thumb. Is just don't think we're terminated. Yay, shredding all this stuff. It's keep it for 7 years because you may need it.
Yeah. Hey, I paid attention to those videos. I know records retention when I see it. I knew it was 7 years. I already knew the answer before I asked it. Ladies, as we kind of put a bow on the episode, and Kathleen, I'll start with you, and Dal, you can chime in here. But for the employers out there that are listening, what are some common mistakes you've seen employers make when they're going through these planned terminations? How should they avoid these mistakes?
Well, I would say one is we've already kind of touched on it, which is not correcting failures, as part of the termination process. That's a big mistake because they can still be audited. Once the plan terminates, they can still be audited. And that's another reason for that record retention that we talked about, because and the other reason why you should do corrections, and it doesn't really cut off the problem. They can be audited for several years. That kind of is open to that. So it's important. That's the one mistake I see a lot of. Another mistake is when there is a merger acquisition situation and they fail to terminate the plan prior to the close of the deal, and then the new owner is kind of stuck with a plan, and they may, and then they can't just terminate it. They have to, maintain it or merge it into their plan, that kind of thing. So those are a lot of the mistakes that I see.
Right. I think the biggest mistake I see is not terminating the plan and simply abandoning it. Some employers will ditch their third-party administrator, ignore communications, pretend that they have no responsibility with regard to this plan, usually because they've gone bankrupt or have become insolvent and closed their doors. But you can't just abandon a plan. The employer does not, even if the company ceases to exist, there's continuing liability for the plan. So those assets are somewhere, and they need to be distributed, pursuant to a termination in an organized way under ERISA, et cetera. And it's it's human nature that people might not want to think about this plan. It's the last thing on their mind as they close their business, but it's still there, and it's their responsibility.
Yeah, and there is a program called the Orphan Plan Program, which always kind of makes me a little sad. Orphan plans are ones that have been abandoned, like Dahl's talking about. So there's a whole program, and they have to go and get a trustee, appointed, who kind of sees the sort of the unwinding of the plan. But yes, I agree with Dahl. That's in those situations where the company's gone under, there's a high likelihood that the employer might just walk away, and the plan's just sitting there without operation, protection, and participants are stuck.
Yeah. Yeah. Well, ladies, as always, I appreciate the time, the insights, and breaking this down to the audience. Appreciate it, ladies.
Thank you, Mike.
Thank you, Mike. You're the best.
And thank you to everyone out there for listening to this installment of Employee Benefit Plans and Business Sense. These two are the best. I'm not the best at this stuff. If you're considering terminating a retirement plan, you need guidance. You don't need me navigating the termination process. You need Dahl and Kathleen. Do me a favor, visit klblawgroup.com right now to connect with either of them. And do me one more favor, as always, hit like, hit subscribe, leave a review, comment, share the episode with someone who needs to hear it. I'm Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.